Hey everybody, Nate Eaton here with EastIdahoNews.com. I have just been to the courthouse and obtained the notice of appeal in the Vallow Daybell case, and I want to explain a little bit about what her attorney is asking the Supreme Court to consider. Before I do, this is a pretty routine type of filing, and I know a lot of people might be like, she's appealing, how can she appeal with all this evidence and this and that and this? It's actually somewhat procedural when they do this. A lot of felony cases, most felony cases, I would imagine, appeal, especially murder cases. And this was to be expected, but it's a 4-page filing. Vallow Daybell, of course, was found guilty back in May of several murder charges, or 2 murder charges of her children, conspiracy to commit murder of Tammy Daybell, conspiring to murder those children, JJ and Tylee. And then she was sentenced to life in prison without parole on July 31st. So Jim Archibald, her attorney, filed this motion with this notice to appeal, and he is asking he's asking the Supreme Court of Idaho to consider several options, to think about these options. So how it works from here is Jim will no longer be on the case for the most part. He might handle 1 or 2 other filings, but he's asking that the state appoint an appellate attorney. The prosecution will also have an attorney appointed for them by the Idaho Attorney General's office. So now it's 2 different attorneys that are handling each side. And then eventually they will go before the Supreme Court and submit briefs and present oral argument on why the case should be overturned or should not be overturned. So, and that could take some time. That could take 2 to 3 years, because they're going to print off a transcript of every single word said at the trial. Jim Archibald is asking for a transcript for every pretrial hearing, the sentencing hearing, all the hearings that Lori's been involved in. So there's a lot to go through, and they have to study every aspect of the law. It can take some time. But here are there's 16 specific issues that Jim Archibald is asking the Supreme Court to consider. 1, I'm not going to go through them all. We're going to post this entire thing at EastIdahoNews.com, but I'll go through a few. 1, did Judge Boyce err in finding that Lori was competent to stand trial even after she spent 10 months in a mental hospital? So now they're going to have to go through and decide on that specific issue. Was Boyce wrong in saying she was competent versus not being competent? Issue 2, did Judge Boyce err when the court denied the defense expert's requests to send her, Lori, back to the mental hospital rather than proceed to trial? Was the defendant's constitutional and statutory rights to a speedy trial violated by the government's repeated requests for a continuance? Was the defendant's constitutional and statutory right to a speedy trial violated by the court's trial setting? Did the court err in denying defense challenges for cause of trial jurors due to bias or hardship during jury selection? So they're going through kind of every aspect of this. Did Boyce make a mistake in jury selection by allowing certain jurors on even though the defense challenged them? Did the government, the prosecution, commit irreversible errors in its opening statement to the jury? Did Boyce err in allowing the government to produce evidence of other crimes or acts against the defendants under Rule 404B? I don't know if you paid attention in the trial. There was a lot of objections under Rule 404B. This was the prosecution bringing in evidence or asking witnesses about the crimes in Arizona against Charles Vallow and Brandon Boudreaux that don't have anything to do with the Idaho case. At least under the eyes of the law. Legally, they don't. And the defense objected to all of those. So they're going to ask the Supreme Court to take a look at those. And then there's several other arguments, several other issues here that they want the Supreme Court to look at. For instance, the sentencing. Did the sentencing court abuse its discretion by ordering the defendant to serve 3 consecutive fixed life sentences without parole? Was the sentence too harsh? That's what they want the Supreme Court to look at. Did the sentencing court abuse its discretion when it ordered the defendant, who has been found indigent and has a public defender and has been ordered to serve life in prison, to pay $165,000 and $18 in fines and court costs? They're saying, did the judge abuse that discretion? And if he did, that's why one reason that this thing should be overturned. So again, Jim Archibald then says, in addition to the standard transcript of the trial, I want you to print off, I want you to prepare additional portions, including the competency hearings, the mental hospital hearings, the pretrial motions, the hearings at the jury trial, the sentencing hearing, all of that. So this was filed last week. And again, now the wheels of justice grind slowly, as they have been. There's some extra complications here, of course, because Lori Vallow Daybell faces those charges in Arizona, and Arizona had said that they will extradite her back to Arizona. She has not left the Idaho prison yet, the Pocatello Women's Correctional Center, and she remains there. And if she goes to Arizona, she won't be able to talk with her attorney here in Idaho, her appellate attorney. So that could be put on hold again. Until they then send her back. If they decide to send her back, if they keep her in Arizona, who knows what happens with the appeal here. There's a lot of unknowns, and I'm not going to pretend to know, and I don't even know if the officials in charge even know what's happening. But what we do know is that the appeal has been filed. The notice of appeal has been filed. It's going to now work its way through. There won't be as many updates now in this case as there were when it was going up to trial, because things were being filed all the time. But if the Supreme Court will hear this case, assuming everything goes as it routinely does, there will be oral arguments. And those oral arguments, the Supreme Court does televise those, or does record them. I don't know if they broadcast them live, but you can go back and watch them. So there will be cameras in the hearing when it comes down to the oral arguments on the Lori Vallow case, with the Idaho Attorney General having an attorney there, and then the appellate attorney on the defense side having one there. Whether that happens in 2 years or 3 years or 10 years, who knows? It could be there. And then after this appeal goes through, assuming the Supreme Court denies it, she then has another chance to appeal based on ineffective counsel. She can say that her attorneys did not represent her, and then it could go through the process again. And then that's it. No more appeals after that. Chad Daybell, still set for trial April 1st. I haven't heard much from John Pryor lately. Not a lot of court filings going on. Well, I would imagine those will pick up now that the fall's here as we get closer. September, October, November, December, January, February, March. 8 months away. It'll go fast. It'll be here. And of course, he could take a plea agreement if one is offered or he comes up with one. So that's the latest today. If you want to read the whole appeal, the whole notice of appeal, we have it at eastidahonews.com. You can read all the words yourself, and we'll see what happens next in the Lori Vallow Daybell trial. Still working on this case. I know many of you have asked, and there may be some news coming, additional news, hopefully soon, concerning this case. So stay tuned. Thanks for watching. We'll see you.